How many days after Kevin McCarthy was sworn in as Speaker did you subpoena his records?
I don't recall, but those two things had nothing to do with one.
It was 16.
You're about to see the moment Jack Smith realized he wasn't just answering questions, he was fighting for the survival of his investigation.
Mr. Smith, in January of 2023, did you subpoena then Speaker of the House Kevin McCarthy's toll records?
Yes, sir, we did.
Yes, you did. And the subpoena covered the time period between November 2020 and January 2021. Is that right?
I'm sorry, sir, could you say that again?
We're not going to delay like this. The subpoena covered the time period between November of 2020 and January 2021. How many days after Kevin McCarthy was sworn in as Speaker did you subpoena his records?
I don't recall, but those two things had nothing to do with one.
It was 16 days after becoming the highest-ranking Republican in the House of Representatives. You subpoenaed his toll records. Do you agree that that might reasonably be considered a violation of the speech or debate clause?
I do not, and I want to be clear that the toll records...
You were collecting months' worth of phone data on the Republican Speaker of the House, the leader of the opposition, right after he got sworn in as Speaker, all around the time of a major vote. That sounds like a flagrant violation of the speech or debate clause to me, and I think most people agree with me. And Speaker McCarthy had no recourse, did he? Because you issued a non-disclosure order ensuring that neither he nor any of the American people knew about these subpoenas. Is that right?
The toll record, the non-content toll record subpoenas, we did secure non-disclosure orders for those subpoenas.
You did, and let me ask you, Mr. Smith, at the time you secured those non-disclosure orders, was Speaker McCarthy a flight risk?
The non-disclosure order was based on concerns about...
Was Speaker McCarthy a flight risk?
He was not.
He was not. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution.
Sir, when securing a non-disclosure order, the risks don't have to be associated...
You think that the Speaker of the House is a flight risk?
The question?
No, this is not your time. This is my time. You think the Speaker of the House is a flight risk? You think he's going to hop on a plane and leave the country?
No, what I was trying to explain is with respect to a non-disclosure order, the risks aren't necessarily associated with the subscriber to the phone. They're the risks to the investigation.
I think that you were using, this was clearly in reference to Speaker McCarthy, and you were using clearly false information to secure a non-disclosure order to hide from Speaker McCarthy and from the American people the fact that you were spying on his toll records. But I've got more, so let's move on. In May of 2023, you also issued subpoenas for toll records of 9 U.S. senators and an additional representative. Is that right?
In May of 23, we did issue...
You did, and there were non-disclosure orders in conjunction with those subpoenas as well, right?
That's correct, consistent with department policy and the law.
So again, nobody would know what you were doing. The senators would, and the representatives would, and the American people wouldn't know what you were doing. Is that right?
The toll records that we secured and the non-disclosure orders were consistent with policy and consistent...
And you knew whenever you were doing that there was a risk you were violating the speech or debate clause. Is that right?
The toll record subpoenas that we secured were with the concurrence of the public integrity.
Your own analysis says that you knew there was a risk you were violating the speech or debate clause. I have it right here. This is an email from John Keller at Public Integrity Section to your team. As you are aware, quote, as you are aware, there is some litigation risk regarding whether compelled disclosure of toll records of a member's legislative calls violates the speech or debate clause in the D.C. Circuit. That's from your own analysis right there. So you did know, didn't you?
Sir, with respect to the item you just put up on the screen, the last sentence states...
oh, we're going to get to the last sentence.
Okay.
We're going to get to the last sentence. And you cite case law in here, quote, the bar on compelled disclosure is absolute. Is that right? Or do you think that you didn't have to abide by that precedent?
To be clear, this statement is not from my office. This is the statement of the Public Integrity
This is your
Section.
justification for those subpoenas and NDOs that you ordered. This was part of your analysis. It's a cursory analysis. I think it's worth noting. But let's get to that last sentence then. Quote, given my understanding of the low likelihood that any of the members listed below would be charged, the litigation risk should be minimal here. In other words, you're using a novel legal theory, which you knew was novel, has never been tested by any court. You're not charging any of these members. Nobody's going to know about it because you issued NDOs. Nobody's going to sue this, so who cares? We're going to do it anyways. I mean, you walked all over the Constitution throughout this entire process.
Mr. Chairman, the gentleman's time's
spying
expired.
on members of Congress, and you know it. It's absolutely disgraceful.
The time.
I yield back.
Gentleman yields back. Not going to be charged. They're not going to see it. They're not going to know because we're not going to tell them. So let's go ahead and do it. It's exactly what happened. The gentleman from Tennessee is recognized for 5 minutes.
Thank you, Mr. Chair. Mr. Smith, it's great that you've been allowed to come here and testify to the American public. Is there anything you'd like briefly to discuss that Mr. Gill brought up on the reasons why you needed those phone records and the limitations that you thought might have been on you and the prosecution to risk the investigation?
Sure, and I would begin by pointing out that the email that was referenced wasn't a justification from my office. It was an email from the Public Integrity Section to my office approving the subpoenas. The subpoenas that we secured with non-disclosure orders from a judge because I had grave concerns about obstruction of justice in this investigation, specifically with regards to Donald Trump. Not only did we have the obstruction of justice that we were investigating in the classified documents case, but I was aware during the course of our investigation of targeting of witnesses during the course of the conspiracy itself. There were election workers who had their lives turned upside down and received vile death threats because they were targeted by Donald Trump and his co-conspirators. I had a duty to protect witnesses in this investigation. That risk, that threat to witnesses was only confirmed when we went forward in this case and Donald Trump suggested that one witness should be put to death and then also issued a statement to the effect of, if you come after me, I'm coming after you. In my mind, I can't think of a more direct threat to witnesses and individuals involved in that proceeding. Given that sort of threats, it was, in my view, completely appropriate to protect the integrity of the investigation, to protect against destruction of evidence, and to protect the witnesses in our case.
And just to make clear, you did not see any of the discussion. There was not any, it was just the content that they made a call to the president and vice versa, but nothing about any content whatsoever. That's
correct. A toll record subpoena gives you who a call is from, who it is to, and the length of that call. It does not tell you the content of what people are speaking about.
You felt that you had a case that was one that you would win beyond a reasonable doubt, no moral certainty. Is there anything in your facts that you had that you would have used at trial that you believe has not been presented to the public in the past or have been misrepresented to the public?
Is there anything?
Essential facts that you had that you felt would have resulted in a conviction of the president on the charges that he was indicted upon?
I think my report, the report of our case, the final report, summarizes the evidence, I think, in a way that is gives a fair reading of the strength of the case.
And you have no question but have been successful before jury?
My review of the case, I came to the conclusion we had proof beyond a reasonable doubt. We were ready, willing, and able to go to trial in the case. Of course, as I said in my opening statement, prosecutors can't control outcomes, but I felt confident in pursuing the case to trial. We followed policy throughout my investigation. My job was not to set policy, my job was to follow it, and that's what we did.
I want to thank you for your service. I think you're a great American, and you came out of this as being somebody who people can respect and look up to in a fashion that we should be instilling people's desire to go into justice, to go into law, and to go into government. And you're an example of the type of person they should follow. I yield back the balance of my time.
Gentleman yields back.
The legal battle is just getting started. If you want to see who wins the next round, hit the like button and subscribe for daily political updates.